Ari Curtis.
Thank you, sir. Curtis, we've got some old misdemeanor matters that we're going to deal with first. You missed some court dates. When you missed those dates, a judge issued an arrest warrant for you.
I didn't have.
Hold on, sir. Hold on. This is the easy part. I'm just going to give you a new date and make sure you show up for these court dates. And we'll get to the harder part later. There's a lot here. All right. As to these matters, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, the court will provide one for you. Do you understand those rights, sir?
Yes, sir.
All right. This one will be ticket U 50509-619, charge of entering vacant building without written authorization. Ticket P 1086428, driving while license not valid. Ticket P 1219403, failure to display valid operator license, no insurance, misdemeanor, and driving unregistered vehicle. Ticket P 1306329, supplying false information to a police officer. And ticket P 1341069, driving while unlicensed. Sir, these are all misdemeanor charges. Maximum penalty you face on each is up to 93 days in jail and or $500 fine. What I'm going to do is set aside the arrest warrants, enter not guilty pleas on your behalf, and give you a personal bond. Your next court date for all of these will be a pretrial on June 13 in front of Judge Jones here in 36th District Court. Now for your other matter, that's going to be case 23056788, State of Michigan versus Ores Demari Curtis. Counsel.
Jennifer Douglas for the people.
Yes, Your Honor. Brandon Bird on behalf of Ores Curtis, my client, waived his right to formal reading inside the Constitution.
Court will enter not guilty plea on your client's behalf as to bond.
Yes, Your Honor. People would note that the investigation report indicates this is the incident that occurred about 128 into some context. The complaining witness is the mother of two children, two defendants' children. They have been separated for at least a year, and they were together for 13 years before that. About this time last year, in May of 2022, the police had responded to this location regarding the complainant and the defendant. Complainant told police that the defendant had stolen her car while she was out of town and some drugs. Unfortunately, because of the warrant review that was just recently reviewed, but he at that time, back in May 2022, the complainant indicated that he came over to her house, allegedly to help with her kids while she was out of town, and then he stole that car and told her that she was never getting it back. So in the situation here, at about 1:20 a.m., she's in her living room, the defendant kicks in the front door, and then he just starts destroying things. He hits the complainant multiple times in the face with a fist, grabs a knife, and threatens to kill himself. The defendant is especially a danger to the given the background of the couple, this isn't the first time that the police have responded to this location, that the defendant is threatening to kill himself and his opponent. We are asking for a bond of $100,000 with a GPS tether, no contact with the location or the defendant, and house arrest.
Thank you. Ms. Counsel.
First of all, about the stolen car, I don't see that in the report. About the car where he took the car. Okay, Okay, and we just ask that you can provide us, that information, especially according to the contract between the ACLU, we're supposed to be providing all the information that, prosecution has in this matter, or I ask you not to take that into consideration. But, respectfully, my client indicates to us that he's a 36-year-old lifelong resident, 3 children, lives by himself, indicates there's no prior criminal history, not on probation or parole, works for a, manufacturer, who makes drug products for the property guideline. That's before including his 3 children. Does have some college behind him, and respectfully, we have to support, there is a story behind it, with my client said, and, my, first of all, we don't accept these allegations, but my client states that he put a house in the complaining witness's name. Fixed up the house, 20,000 into this house, and now the complaining witness wants this house back and is making allegations against me, and respectfully, I do understand that these are some allegations, but my client doesn't accept these allegations. True, believes she's being lied on because the client really wants this house back. Respectfully, we have to support the person's done. And, disrespectfully, we do have all information that the prosecutor may have provided, so we can go over that.
To the extent that prosecution has any evidence or history on this defendant that they want to bring to the court's attention, that of course does need to be shared with defense counsel. But here's what we're going to do as to this case. Sir, while this case is pending, you are not to possess a firearm, a knife, or any other dangerous weapon. You have no contact with Ms. Ashford. Don't go to her address. Don't call her. Don't text her. Don't reach out to her on social media. Don't have anyone contact her on your behalf. Also, you're not to go to the Corville Street address for any reason whatsoever. Should you post bond, you will be on a GPS tether on house arrest. If you leave your house, you're going back to jail. Is all of that clear to you, sir?
Yes, sir. Excuse me, Your
All
Honor.
right.
I
Hold
have,
on,
I
sir.
have,
Please don't say anything. Please
Your,
don't say anything.
your attorney, sir, is advising you to exercise your right to remain silent. I would suggest you follow his advice. He actually does know what he's doing some days. Court's going to set bond in this matter. Court finds that the allegations of kicking in the front door in the middle of the night and pulling a knife on complainant, that defendant does pose a threat to the complainant. Court's going to set bond at $100,000 cash or surety. That's going to give rise to a bond redetermination hearing on Wednesday, May 10th. Probable cause conference is May 16, preliminary exam May 22, both in front of Judge King. That bond rehearing is in front of Judge McConico. Thank you, sir. You can step aside.
excuse me, sir, please, can I please say this? I have to be at work Thursday. I was stabbed in my leg by her Wednesday. And my union rep had told me, I work at Chrysler. I have a union rep, and she told me that I had got the days off for me being injured. Upon me being injured, I've been at my mom's house. I have not been anywhere by that woman. That woman was here at DDC for 3 days, and I was told that the charges was dropped for her stabbing me. I did not go to that lady's house. The officers on the scene showed that the door was not kicked in, and I was nowhere over there. They picked me up from my mom's house on Braingard Street because they had just kicked me out of my house because it was in her name. I
Right, sir.
really,
You said,
really
hold on. You said what? You have to be at work what day, sir? Thursday?
yes, Thursday this week. I can get the
All right.
tether, but
So-
I understand that the tethers don't go on until like Wednesday. If I could please get a personal bond and get to work, I will go to work and go to court. I swear to God, I do not have any money. I spent all my money trying to fix the house that I'm living in. I have never had any contact with her. Saturday was my daughter's birthday.
All right, sir. Thank you. Thank you for your input, sir. You will, as I said, Wednesday morning at 9 o'clock in the morning, you're going to be in front of Judge McConico, and he may lower that bond and let you out at that time. So I'm sure your counsel will bring that up Wednesday morning, but for the time being, the bond's going to be $100,000 cash or surety. Thank you, sir.
Can it 10%? I'm sorry for asking and negotiate. Can it be 10%? Like 100,000, 10%?
Not negotiation. Not negotiation, sir. I quit doing record deals 20 years ago.
No,
Have a good day,
I'm trying to get out so I can get the money for you and get to court. That's all.
I understand all that, sir, and you'll be able to present that to Judge McConico Wednesday morning.
Yes, sir.